Yes, sir. Y'all already know who it is, man. It's your boy Big 36, the Project Slumlord, King of the Slum Business, and we back with another one, man. And today we're gonna be reacting to YSL's indictment case. Um, Today, Doug was in court, so we're gonna be reacting to his the footage of his court case. Um, so y'all get into it with me, man. Y'all don't forget to like, comment, subscribe. You feel me? Matter of fact, I don't even care if you like or comment or subscribe. But what I do want you to do is just like, don't comment. You ain't got to subscribe. Just like the video. That way this video can reach the algorithms and, other people can see it, man. If you really rock with me, man, hit the like button, man. I appreciate it. It'll go a long way. But without further ado, man, let's get into this video.
Price to rock this ice, tell me what you niggas know about sacrifice.
All right, so as y'all can see, man, we got Thug in court right now. And we about to just, tune in and see what's going on so we can catch up on the YSL Young Thug court hearing. And this is taking place in Fulton County. This is the RICO case. For y'all that don't know, that's just tuning in and living under a rock. But let's get into it, y'all.
When did you file those?
They were filed on the 22 pack. It was just the two that I handled that Mr. Floyd didn't handle, so we said we could do those anytime. I can do them now.
Yes, ma'am. Okay.
And the other three evidentiary motions need the three witnesses.
That's fine.
Who are available on the 28th.
Okay.
And Your Honor, I also spoke to Mr. Adams this morning. Mr. Adams was discussing his client's motion to suppress, and I believe he may also wish to be heard on the 28th. And our witnesses could be available that day as well. So we were just curious if we could get some guidance from the court on whether to have those out-of-state witnesses come in again.
That's the motion suppress that was begun previously with the out-of-state witness. Motion suppress statement from DeKalb County. Mrs. Steele had
Gang activity. Committing murder, killing
I'm
someone.
sorry, y'all. That's my bad.
We don't have any objection to him testifying at some later point when he's done with the report and we can actually have access to it. But I think for whatever reason, and then it's kind of, we're going to, Mr. Burning is going to be called, I guess.
I just wanted to say, man, yo, free slime, you feel me? Free Thugger.
After Dr. Henninger, we're going to object to him being called. I think I speak for myself on behalf of Mr. Williams as well as other defense attorneys.
All right.
Mr. Burney is going to be called as a cell phone location expert. My understanding is that he has not prepared an actual report, but is in the process of doing so. We would object to him testifying prior to him completing that report and letting us have access to it, since that essentially is going to be the subject matter of his testimony or his qualification. We don't have any objection to him testifying at some later point when he's done with the report and we can actually have access to it. But I think it's counterintuitive to have him testify and try to be qualified now on something that he's not completed yet, that we would need in order to properly cross-examine him or voir dire him.
All right. Madam?
Your Honor, Mr. Adams is absolutely correct. He has not finished his report yet.
So basically, he's pretty much saying that a police detective who did a report on the case, he wants to testify, but he's not done with the report. So how could you testify? You're not done with the report. So Thug's team, the defendants, they're trying to keep him from testifying until they can get the reports to see what he came up with.
However, we brought him here today. We had the Jobber hearing scheduled. We believe that it would be appropriate. So there's different prongs of Jobber. It's whether the person's qualified to offer the testimony, whether the science itself is reliable, and whether the application, whether they have reliably applied the reliable method to the thing they actually tested. So if the court would like to reserve that third prong for later, we can present the evidence on the first two prongs today and simply traveled from Alabama today, we thought perhaps we could at least get his qualifications and the reliability of the methodology itself on the record today. And if the court wishes to reserve its ruling until immediately prior to his testimony at trial, or until the report's created, that's fine with the state, Your Honor.
We'll be guided by whatever the court decides. It just seems a bit counterintuitive to kind of have them start testifying and then bring them back. And here's the other thing, just from a practical standpoint, let's say he gets qualified as an expert, but then the report doesn't come in for whatever reason, and then it's kind of, we're going through the exercise for nothing. It just seems to make sense to have him come when the report's done, and we can just kind of do it whole hog, if that's a phrase.
Okay.
Which I believe that makes sense. Like, it makes sense to me. Like, why would you come have somebody testify and they don't even have the whole, like the defendants, they don't even have like the whole discovery of what's happening so they can properly defend the so-called evidence that's being presented. So it makes sense.
Your Honor, again, I'm just going to reiterate my request. He's driven in here from Alabama. We'd like to just put the first two on the record so that if we...
Why didn't you have him come today then? I mean, it does sound counterintuitive that he would probably at least need to be able to testify, hey, I did this particular test with these in this particular manner, and I followed these particular, these methods. Consistent like your other cell phone expert did. When's he going to finish his report?
Should be fairly soon, Your Honor.
And it's got to be provided to the defense.
It will be.
So I think it's probably a little much. Yeah, it's probably a little bit not ripe quite yet. Yeah.
Premature?
Yeah, ripe. What I'm looking for. Yeah.
Shout out to this judge though. Like, I understand we dealing with a RICO case, but this judge has not been biased. He has not been like, he just seems like a judge that's really looking for the truth. Like, he's not making the prosecution job easy or the defense job. He's not allowing nobody to skate through nothing because the prosecution has been on the ringer. The last court date, they was trying to get Thug's lawyer was trying to get one of his charges dropped in the case because one, when they arrested him one time, they took his phone like 2 years ago, and they took his phone and they were supposed to give his phone back, but they never gave it back. They kept it. They still got his phone. They never gave it back. So once the RICO came out, which back then when they took the phone for the last charge he was arrested for, he ended up, like I said, they were supposed to give him the phone back, but they didn't because they had a 24 to 48 hour window, or if I believe like a 10-day window to go through. They had like a 10-day window to get into his phone and get all the evidence they need. So pretty much they never did that within the 10 days. They never gave him his phone. So a year later, when this case come up and he gets locked up, and the reason why they couldn't get in the phone because I guess the whatever phone company he was with, they didn't have the technology to get into the cell phone at the time. So apparently they do now. So after a year later, in this case come up, they finally get in the phone, and that's where they find the evidence of, Thug talking on the phone and so-called saying like people got to be sacrificed for the greater good of the gang. You feel me? Like that type of stuff. Like they got all that off his phone. So Thug lawyer, pushed to have that thrown out because it violated the laws that they had a year ago when they had the 10-day period to get to the phone. So all the evidence they got after that 10 days is admissible. And so they tried to bring that back up to the judge. Well, the prosecution tried to bring it up to the judge, and Thug lawyer tried to get it dismissed, and you know the judge was really on I ain't gonna say on the side of Thug. He just understood that what the prosecution did was wrong. Like you can't, we're not about to allow y'all to just do this. You get what I'm saying? So shout out to this judge, man. He seemed pretty fair. He seemed like, you know, he ain't out here trying to just lock niggas up. And he don't seem like he, you know, he's working with the prosecution, like he's making them do their job. But let's continue.
Yeah. So let's just you can explain to him that that it would make better sense if we did, and maybe you can ask him when his report's going to be due, because we can. I mean, if worst comes to worst, I can always take it before he testifies. I can qualify him. I mean, it took Mr. Worrell probably about maybe 40 minutes or something like that, 30, 40 minutes. So I mean, there's no reason we couldn't do it prior to trial, or prior to his testimony being offered.
Okay, I can go check with him if he's going to report back to that and report back before we want.
Okay.
And that's old boy who baby mama called jail. It was telling him he better snitch. He in jail, he in court smiling, bitch. No, you ready to go home with your pussy ass. These niggas better not be telling on slime, you feel me? But you know they is. But this is old boy who went viral for baby mama telling him from the jail, you need to think about your son. You need to come home. Tell on them boys. Move.
Just wait a second, and when Ms. Rosenwasser comes back, we approach.
Yeah.
Or Mrs. Smith.
But Thug look like that. You know what I'm saying? He seemed like the only one that's holding it down for real. You get what I'm saying? Like everything on him, they trying to put everything on him as big slime. You feel me? I'm gonna just tell y'all real shit. If this don't show y'all that these street niggas ain't who they say they is, and that all these niggas be telling, like ain't none of these niggas really like that for real. Ain't none of these niggas really like that for real. Out of a group of 100, maybe three. Maybe three. Thug holding that shit down though. Shout out to Thug. It's only a state case, bro.
Yeah, sure.
I know they ain't got Thug in no motherfucking raggedy ass chair in this high profile ass case. Who all these niggas is? They don't form the Black Avengers. Who the fuck is all these niggas? Boy, is this Thug Legal Team? Who this? Thug done assimilated the Black Avengers, nigga. Assembled. That's assimilated. Okay, gang up here, you feel? Gang in this bitch. That's them, y'all. They keep cutting out the sound. I guess they don't want you to hear what's going on. All right, y'all. So we don't really know what's, you know what I'm saying, what's going on right now. I guess they pretty much just trying to see what's gonna happen with the guy that's supposed to be testifying, who came unprepared, who came from Alabama, who the prosecution is trying to get him to testify without having, you know, without the defense being able to see, you know, what's going on, like in his case. I mean, in his discovery that he, I guess, what he's investigating. So I guess he said about 30, 40 minutes. They about to pretty much. So I'm gonna try to fast forward this a little bit, speed up the process, because we ain't got the time. Okay, so they about to get him to the, okay, the sound back in.
Well, I filed a motion to suppress the identification based on what the transcript indicates happened, but I don't have the actual photo lineup yet in discovery.
Well, of course, until they admit it, he could have that typical motion that we had. I'm running out of time, so I have to kind of.
I understand. That's fine.
Before that's admitted.
Thank you.
Your Honor, we confirm, Deputy Hall is, he's on his way over here. We should be able to take him after, he's on his way. If he's not here, I can be ready to argue.
All right, we said as far as our issue of the 8-4 call, the 8-4?
Yes, sir. Yes, sir. Yes.
Okay, all right. Okay, can we call Dr. Need to have a conversation, either in love tones or wait until we have a break, okay? All right, Dr. Manager, good afternoon, sir. You approach the witness stand. Once you get there, if you would be so kind, you turn face to Lieutenant Gibson, respond to the witness, sir.
Place six. You remain standing, sir. Raise your right hand. You swear or affirm that the testimony you give in this court will be the truth, the whole truth, and nothing but the truth, so you got.
Yes.
You may lower your hand. You may be seated. For the record, please state your name, spell your first and last word, and state your occupation.
Okay, my name's Dr. Michael Henniger. Can you hear me okay? Okay, my name's spelled Michael, and then Heninginger. And I am a forensic pathologist at the Fulton County Medical Examiner's Office.
Good afternoon, Dr. Henninger.
That nigga look like he should be on trial for something
How
else.
long have you been a forensic pathologist?
I started working at Fulton County as a forensic pathologist. It's my first my job, basically, in 1995 in July.
Okay.
So since then.
Okay. And can you tell the court a little bit about your education?
Yes. I started out at Utah State University. I received a Bachelor of Science degree in biology. And then I went to medical school at the University of Utah, and I received an MD degree. I went into the military and did an internship in internal medicine at Keesler Air Force Base in Biloxi, Mississippi. I practiced primary care medicine for a few years. After I finished my commitment to the military, I went back to Utah. I did a 4-year residency in anatomic and clinical pathology, and then I did a 1-year fellowship up in Minneapolis at the Hennepin County Medical Examiner's Office in forensic pathology. And when I finished that training, I came to Atlanta.
Great.
Began to work for Fulton County.
When did you, when did you start studying medicine?
I went to medical school I started medical school in 1982. I did pre-med undergraduate, so basically when I graduated from high school, I started doing pre-med classes. Okay. And even some of the high school classes were, like they teach physiology and biology in high school. So, I mean, I'd have to go back to the 9th grade to really say that's when I started studying things that were academically going to lead to medicine.
Thank you, sir. Are you involved in any professional organizations?
Yes, I am.
And what are those?
Okay, there's 2 of them that are that people in our field belong to. There's one called the American Academy of Forensic Sciences. It's a big, huge group of people that from all different disciplines, not just in medicine. There can be anthropologists and dentists and different areas of expertise. The one that's particularly focused on forensic pathology is called the National Association of Medical Examiners. It's a smaller group, but they're all forensic pathologists, most of them anyway. And they I also belong to the American Medical Association.
Your Honor, at this time, I'd like to move into State's Exhibit, Proposal Exhibit 16 on the witness. Permission to approach the witness?
Anybody not seen state 16, Dr. Henry, you see who? All right, you may approach.
Thank you. Dr. Henninger, what is that, doctor? Do you recognize that, doctor?
This is
Yo, he got an extensive ass educational history. That nigga done did a lot of shit, man. He really did. Shout out to him, man. But he need to do something with that hair. He didn't know he was coming to a televised court case today? Or you think he tried to brush it up to the front so he could cover that bald spot right there? He ain't got no tape line, y'all.
CV that I have on my desktop. That's kind of a basic summary of simple basic summary of my CV.
Has there been any alterations to that?
No, there's. Trying to see if it's. I think I had one more article that's on this, but that's just probably since I gave that to whoever did. But anyway.
Any objection to state 16? All right, state 16 is admitted.
Dr. Henninger, am I pronouncing that right?
Yeah.
Okay. Do you have any certifications?
Yes, I'm board certified in anatomic and clinical pathology. I'm also board certified in forensic pathology.
And with those certifications, are there any kind of continuing education courses?
Yes, there are.
Okay, can you tell the court a little bit about those?
Okay, continuing education, basically, on average, once a year, we have a national meeting that we can go to, and they usually last approximately a week, and their lectures and papers are presented, and there are discussions about various fields. I've generally gone to those. I've gone to more than required some years, and occasionally I do present things. I'm not an academic forensic pathologist. I'm not one of the people that are in the middle of doing that and doing the major lectures, but we attend those, and that's a requirement to maintain a license to practice medicine.
Are there any tests you regularly have to take?
Okay, they have instituted that, but when I got board certified, they hadn't, and I haven't had to take the tests. So there aren't any of that. I mean, I've helped write the test questions when they request that. I'm kind of, my level of experience, I'm more on that side of it. But.
Sure. So I want to kind of transition. How were you trained in performing autopsies?
Okay, that's a very good question. We start out, basically when I was an undergraduate in college, my last year, we had an anatomy class at the college, and we had a cadaver that we looked at. So we started learning anatomy at that point. In medical school, we had a year-long course in anatomy, and we did basically one autopsy all year long. So we went through every single thing that you could think of. And then when I was a fourth-year resident, I did a rotation in pathology, and they let me kind of do an autopsy and under close supervision. So those are a few, and that's more than is typical for students today, but probably pretty typical for that time. But the real training begins in your pathology residency, where you're required to do a certain number of autopsies. So that's when I started doing autopsies, more than one, and focusing on learning how to do them. And those were hospital autopsies.
He looked like one of them people who like to play around with dead folks. I knew he looked like he should have been on trial for something, just not this.
We're basically looking at people's natural diseases, so it's more closely related to medicine, and the forensic aspects aren't really in that. And then when I did my fellowship in Minnesota, the first day I was there, I did a forensic autopsy under supervision. The second day I had a homicide that ended up going to court, and I was under supervision doing that with really close supervision. So that's how you learn, and I did about close to 200 of those that year. And then when you're in practice, you're constantly learning from your cases. You don't just walk into this knowing everything. And then there's the process where we had a fellowship, and I've helped train other physicians. So that's kind of how I've learned how to do autopsies. It's a work in progress that keeps going on for your whole career.
And do you typically stay up to date with developments in that field?
Yes.
Have you ever taught any classes?
Yes, I don't have that in my resume, and they're not that well documented, but I have taught over at Emory. They had several lectures that they have in all different kinds of areas of pathology, and I've done several lectures on forensic pathology at Emory, and they're geared towards pathology residents, not necessarily forensic pathology residents. Most of the teaching that goes on in our office, we do have little kind of one-on-one training sessions with the fellow, but a lot of it's at the what we call the bench, or at the autopsy table, where you see something interesting, and you show it to the resident, or you're watching what they do and pointing out things they need to do, kind of guiding them through this process. So
How often do you teach over at those classes over at Emory?
right now they were canceled during COVID, and then they haven't really started back up. Or if they have, they're having other people do them I don't know about.
Have you ever received any awards for your work?
I don't know, paycheck. I don't.
He did all that and he never got a reward or a trophy or like honors for what he's done. He said, I don't know, a paycheck? Like, is that a reward?
Not really. It's not. I'm not like the people who get the awards are people who are usually in administrative fees. There's, I don't know. Not really. I guess no is the answer.
Has your work ever been published?
I have been involved in writing articles. The person I worked for 20 years was one of the academic forensic pathologists. He was the head of NAME at one point, and he wrote like hundreds of articles, and he encouraged me, and I did do a few. They weren't really required, so I just kind of plugged away at it. So I have on that resume, I've got a list of articles that I've either written or helped write.
Approximately how many?
That's not the question. He said, was your work ever publicized in the article? Which means, did anybody ever give you accolades for your work and what you've done? No. He published his own articles about, I guess, himself and his work. So technically the answer is no. But of course, you got to make yourself seem more important than what you are.
Autopsies have you done or assisted with over the years?
Well, assisted what's really interesting. Just done. I've done at least 250 for 27 years, 250 each year. So that's up over 7,000 autopsies. As far as assisted, depends on what degree, because we have meetings and we talk about the cases, and the more complicated cases we talk about more. And that would be the total caseload of our office, which is over 1,000 a year of just autopsies, and at least 2,000 cases. So those numbers get really high, but they're not. I think it would be deceitful for me to say, some big, huge tens of thousands of those.
Sure.
I mean,
that says a lot about the death toll in America that actually happens. Like, bro, every year, like tens of thousands of people die.
Involved in the more interesting ones. Most of them are just,
Have you ever been qualified as an expert before?
Yes.
In which states?
Minnesota and Georgia.
Which courts?
Mostly Fulton County. The first couple years I was here, we worked at the GBI, and I testified. It was kind of Fulton County and GBI, we covered both areas. And I did get to testify in several murder trials in various places around Georgia, not in Metro Atlanta.
And about how many, I'm sorry, let me strike that. Have you been qualified as an expert in civil cases as well?
A few.
About how many times?
I haven't kept track, but it's not a lot.
If you can recall, what was the nature of that testimony in those civil cases?
The civil cases I've been involved were usually depositions, and they're usually related to injuries and either traffic accidents or on the job injuries, things like that. Basically they wanted to know the death, the injuries and the cause of death. But I mean, certainly wasn't testifying about all the other things that go into that.
Dr. Henninger, what technique?
So basically, he's never testified in a murder case, but his testimonies that deemed him as an expert were in, work-related accidents, stuff like that.
Techniques do you use to conduct autopsies and determine cause of death?
there's the autopsy itself, which is like a medical procedure where we examine the body in a systematic way. We have investigators that are similar to, some of them have been police detectives, or they're similar to them, but they collect information, and we evaluate that information. And then we have tests that we do, lab tests. Basically, there's toxicology. There can be other lab tests. We have an X-rays that we look at and take. So those are some of the things that we do. And then I guess the other half of that is documentation, and we take pictures and we create a report.
How did you learn these techniques?
By doing them, basically, yeah, when the autopsy itself, we started way back, the beginning, and then the majority of that is exactly how to do them efficiently, how to do them with chain of custody issues in mind, forensic issues in mind. That happens in my fellowship. And so basically I'm doing a case, but a person that's experienced is standing right there, and they let you go as far as you can. And part of being on the other end of that is, is knowing how to step back and look at a fellow who's training, let them go just far enough that if they make little mistakes, they're not serious, and kind of stop them before they cause problems, but not let them get, into where they do really major mistakes.
Do others use those same techniques?
Well, yes. I mean, my experience isn't great, but from what I can tell from the meetings and from, different talking to people, it's fairly homogeneous across the different offices. There are probably minor details that are different in different places that I'm not very familiar with, but I think that's pretty much the standard way.
Okay. And how would you go about determining the cause of death?
Well, the same thing. I want to look at the information, the circumstances. I want to look at the autopsy, if I did it, or else to read the report and look at the pictures if I didn't. I want to see all the ancillary information, and then, think about it. I may even look stuff up. I have textbooks, or else, get online and find reliable sources for answering questions I may not have on the top of my head or whatever, and then make a determination of cause of manner of death.
Do other medical examiners use those same techniques?
As far as I know, all the ones that I'm acquainted with use something very similar to that.
Okay. And do you know, are these procedures published in a textbook?
There's several textbooks that have different aspects of it. I don't know that we have one comprehensive textbook that tells everything you need to know for everything. There's books, a lot of textbooks are just information, like common, like say you might have a chapter on gunshot wounds, it'll tell you about gunshot wounds. And then there are books on procedures, on, how to do basic procedures. And then there are also like uncommon procedure, unusual procedures. And then when you've done it a lot, you can often kind of see where the boundaries are, and you can create like other approaches that are within, the realm that can answer questions.
Sure. What about professional publications? Have those procedures been published in professional publications? Some of
them are published. There's books that have been published systematically by people who are familiar with a lot of different procedures, and then a lot of the articles are like, kind of interesting, unusual situation where they had to do something different than usual. So there are books that do that.
I fast forwarded because he just talking about his credentials and shit. Who care about that?
Yes.
And did you follow all the standard and procedures that you discussed about?
Yes.
Your Honor, at this time, we would ask the court to qualify Dr. Henninger as an expert in forensic pathology based on his number of years of experience, his background, his training, and the fact that this is well-established, accepted field in forensic science.
In the room.
All right. Okay, then the court will designate Dr. Henninger may Dr. Henderson defer the temporary excuse for purpose of the motion. Dr. Henderson, appreciate you coming to visit us.
Thank you.
Good to see you. Just don't discuss the testimony made by the deputy attorney in this case. We'll call you when we need you. Okay?
Okay.
Thank you, sir.
Thank you.
Okay, so George wants you to talk with Mr. Bernini?
He is. We sent him back on his way. He said he's going to try to have a draft report basically as soon as he can, hopefully before the end of the year, and he'll definitely have a final report before trial.
Mr. Farley, if you want to, Mr. Menez, if you want to go ahead and,
All right. Bless me. Now we about to get into something. Now the dude who baby mama was telling him he better tell, his lawyer about to go up and talk. We about to see what he's saying. This is crazy. I just don't understand how you could like just imagine if you sit there, you listen to her, right? And then you tell so you could come home. And then every time y'all get in an argument, she say, nigga, that's why you a rat. Nigga, you told them. You can't say, bitch, I did it for you. She gonna say, nigga, you ain't do it for me. You did it because you wanted to come home.
you have any argument as to the duplicate accounts?
Yes, Your Honor.
All right, go right ahead.
All right. Good afternoon, Your Honor.
Dude look like a public offender. He don't even look like a lawyer. First of all, if you got a full beard, ain't no way I'm hiring you as my lawyer. How many lawyers you see with a full goddamn beard? And this nigga not even like, he look like he like 5'2". Let's see what he said. Let's see if he is good as like, come on, this a YSL nigga. Like, how you get this nigga as your lawyer? Let's see if he good though.
I mainly rely on Meeks v. State, which is 309 Georgia App 855. That held that a one count of theft by taking was subject to a special demurrer because it was entirely duplicative of another charge that was charged in the same offense. And here, Your Honor, I'm basically asking the court to apply Meeks to this indictment the way it's specifically written. In Meeks, the Georgia Court of Appeals held that the accounts were duplicative because they provided no additional facts by which it can be distinguished from the other count, and it alleges neither a different set of facts nor a different date. And so, Your Honor, that's what I allege, that counts 50 and 51 are duplicative of count 49. Count 49 is where Mr. Farley is alleged, along with Mr. Stillwell, Nichols, and Garlington, to have murdered Mr. Drinks. And in that count, they say, the reason why, Your Honor, this is especially duplicative is it says that Mr. Drinks was an associate of a rival gang. So essentially what I'm asking the court here is to find it duplicative, because I know the state's going to say that a gang activity charge and a murder charge are not duplicative, even if it's that murder that is the basis of the gang charge. But, Your Honor, I think that this can't survive a demurrer under Meeks because they write up count 49 as a gang charge. They just don't write the caption. And, Your Honor, the caption is not what holds, it's the substance. And so here in count 49, the substance is the same as counts 50 and 51. Had they not put in that part where it says an associate of a rival gang, then I get it. There's an extra set of facts that, oh, we're saying you killed this guy, and then in this other count, we're saying you killed him as part of gang activity. But 49 says an associate of a rival gang. So because they wrote that in there, and they didn't have to. That's not part of the malice murder statute by any means, but they chose to allege it that way. And so within the four corners of this indictment, of which Mr. Farley is entitled to an indictment perfect in substance and form, here it's duplicative. Had they not put that, it wouldn't be duplicative. But what I submit to the state, what different fact is alleged in counts 50 and 51 that's not alleged in count 49? Because in count 49, they say it's an associate of a rival gang. So if you say someone has an associate in a rival gang, by inference, you're saying that that person is in a gang. Essentially, count 49 alleges Mr. Farley to be in a gang, and it alleges that the person killed was a rival of the gang that Mr. Farley is supposedly in. So count 50 and count 51 that allege the criminal street gang activity with the murder of Mr. Drinks as the subject matter, Your Honor, those are both duplicative of count 49 because they included count 49 as gang activity. So looking within the four corners of the substance of these three counts, there's nothing different in count 51 or 50 that we don't already have in count 49. For that motion, yes, Judge.
Talk to me about the unconstitutionality of the gang statute.
Sure, Judge. So,
And you understand that the Supreme Court already.
I understand, Your Honor. I don't think the Supreme Court's going to consider anything with regards to Mr. Farley because there won't be a conviction. But just out of caution, I do think maybe the United States Supreme Court or possibly some other court might review this, Judge. So I do. Right.
What's your good faith basis to challenge?
Yeah, I can explain that, Judge. The good faith basis is that Rule 418 in combination with the Georgia gang statute just completely flies in the face of the most fundamental aspect of our government, which is checks and balances between the three branches. You know, we have Your Honor representing the judicial branch, we have the state representing the executive branch, we have myself and the other attorneys representing individuals and people in the state of Georgia. And so how it's supposed to work is that we're supposed to be checking each other, we're supposed to be balancing each other. But what we have here is, Your Honor, Rule 418 just completely circumventing Rule 404B and rendering 404B meaningless and robbing both the people of the state of Georgia and the judicial branches of the state of Georgia of any sort of check on the authority of the state to circumvent the legislature, who's elected by the people of Georgia to write the statutes, who wrote 404B. And, Your Honor, under 404B, as the court knows, other acts are not allowed in for propensity. They're only allowed in for limited purposes like intent, motive, absence of mistake.
Wouldn't you agree that it's a different statute promulgated for a different reason?
Exactly, Judge. And what's the huge problem here is that our grand jury proceedings are entirely secret. They're not transcribed. And there is no mechanism for either the people of Georgia or the jurists of Georgia to check the state to stop them from doing what this leaves open to be done. So, for example, which is, Your Honor, they might in bad faith, let's say we have a murder case, and that person accused of murder has an aggravated assault, but there is no other way to introduce that except for propensity. So the judge would say, as the state would know, that, you know, I'm denying your 404B, this is propensity, that's not allowed. Our legislature does not allow propensity. However, 418 does allow propensity. And that's what makes the gang statute and rule in combination with Rule 418 so unconstitutional under the United States Constitution. Because what's to stop the state in a secret, untranscribed grand jury proceeding in bad faith just throw on a gang charge onto the murder charge, then... Right, Your Honor, but there's no one to check them. They're doing it in secret, and it's untranscribed, so there's no one to hold them accountable. We have rules, but without enforcement and accountability, the rule is meaningless. And so 418, in combination with the Georgia gang statute, has made 404B meaningless because all they have to do is throw a gang charge on there in violation of the rules of ethics, which happens from time to time, and they can choose to violate that behind closed doors, untranscribed, and then they can throw up their hands at the end of the trial and say, oh, the directed verdict got granted. We didn't know that was going to happen, wink, wink, but they did know. And the reason they did it and put it on there, even though they knew it would be dismissed by directed verdict is that so then they can use 418 instead of 404B and then bring in, for example, a past aggravated assault for propensity, which is exactly what the legislature didn't want the state to ever be allowed to do. And so
he's saying a lot, which is like hard to keep up with. He's trying to get another charge dropped because he literally is thinking and speaking in the what if scenario, as if this is why they're trying to do it, because if they do this, they can do this, and then this is what they're trying. It's like I don't know. He's not winning me over as a lawyer because he's rambling with like lawyer jargon.
there is no right, Your Honor, but if we didn't have the gang statute, then we couldn't accuse someone of gang activity, and then we couldn't apply 418. We would have to apply 404B, and we wouldn't be talking about propensity. But
bro, if you didn't have any charge, they will figure out something if they want you. So he's really trying to fight is the fact that they throw on extra charges. Like, is he a murderer or is he a gangbanger? Or is he a gangbanger and a murderer? Like, his argument is super weak. Like, you know this dude is going to take any plea that comes his way. Because this lawyer's argument is weak. What did he, like, he can be both. I'm not saying he is. But what I'm saying is a person can be a gangbanger and a murderer. And he could be a gangbanger. He could be a gangbanger or a murderer. Or he could be a gangbanger and a murderer. You get what I'm saying? It took a lot to come out, but I got it anyway. But my point is, just because they throw on the extra charges, the cops are going to throw on any charge they could throw to make sure that they have something to lock you up on. Something. Like you got to have something. They don't feel like they need to be arresting you and nothing just for you to just go home. No. They need something. You get what I'm saying? So he ain't making no good case right now. I told you he sound like a public defender. That's what he sound like. He don't sound like a lawyer. Look at him. Dude drop his head like, shh, man, what the fuck? All that's playing in his head is, man, you need to come home. You need to come home. You need to tell that boy, you need to think about MJ. You better think about MJ.
So do you understand that evidence under our evidence code, Title 24, may be used sometimes for differing purposes, right? So, right?
yes, Judge.
So under the gang statute in 418, it's a little different than 404B and the other purposes for which evidence is admitted, right?
Yes.
Okay, all right.
And that's just exactly, it is the existence of that, Your Honor, that I find to be just totally unconstitutional, because now there is no way to do checks and balances. It's just whatever the state wants.
The legislature wrote or enacted the gang statute, and they enacted 418, right?
Yes.
So they obviously had knowledge of 404B, correct?
Bro, I'm just so petty. I just thought of something, man. Remember, it used to be a meme. A lot of y'all probably don't remember this, but when he was just like, when this dude, the lawyer, was just like, and yeah, that's exactly what it is, Your Honor. It was a meme that said, it said, I knew my cousin was going to jail when that court, he said, Your Majesty. He called the judge Your Majesty. Anyway, let's get back to the video.
Yes.
All right. So, I understand your argument. Is there anything else you wanna put forth?
No, Judge. Just,
okay.
I just ask you to grant that, and then the state can appeal something for once instead of us, appealing everything.
Okay. All right. Ms. Rosenwasser? Any other motions? I think I've dealt with the other. Only one is the 418, and I'm waiting on wait on Mr. Carlson.
Yes, sir. The only other thing I have that I failed to mention is I did have an amended discovery motion that the state's mostly accommodated, but there's one aspect they're not accommodating that I'd like the court to
What is that?
compel them. They relatively recently, sent out these gang profiles on each of the defendants, and then nowhere in the discovery does it say who wrote those profiles and when they were written. And their written response to my motion says, well, you can just call the law enforcement witnesses. But that's exactly why I need Your Honor to compel them to tell me which law enforcement witness produced which gang profiles and when, because even though the state might try to say that's not exculpatory, the discovery statute says it's not only exculpatory things that they have to give us, but anything that might lead to something exculpatory. So the way they've described this gang profile of Mr. Farley, I think they wrote that up after this case already started, and if that's the case, that definitely impacts, my absolute theory of innocence.
Have you had any conversations with Ms. Rosenwasser or Mr. Smith or anybody else in regards to this issue?
No, Judge, only just through our written responses to the
And
motion.
why don't you have a conversation with her about that? Madam, is it that you all willing to, or can you give him that particular information?
Your Honor, I don't want to speak out of turn. I would just request Mr. Farley contact the trial team. I would request Mr. Farley contact the trial team leader to get an answer on that. I do not want to speak out of turn, at least without confirming with them. If he'd come up to me about this earlier, I could have relayed that message and if he didn't answer.
Okay. So why don't you have a conversation with Ms. Love or Ms. Hilton, and then if it continues to be an issue, I'll certainly deal with that. Okay?
Yes, Judge.
Hold on. We got Mr. Carlson here who can talk about 418. Do you want to go ahead and finish your 418 argument, sir, and then I can let Mr. Carlson respond to that?
No, Your Honor. Just to perfect the record, I also challenged the gang statute for violating freedom of speech and freedom of association, but I don't have further argument about that. I just have it in my motion. Everything I object to about 418, I've already said to the court.
All right, Mr. Johnson?
Yes, Your Honor. On behalf of Mr. Eppinger, I wanted to join in Mr. Menendez's motion.
What did any of you ever listen to Mr. Harvey? I hate to cite to him all the time. I hate to cite to him all the time. But he did you all such a solid. He said, look, unless you opt out, everybody else gets to opt in, right?
Well, yes, Your Honor.
Okay, so add to it.
I'm going to add it specifically as it relates to Mr. Eppinger.
Okay, so let's take care of that.
Yes, Your Honor.
But if you start replicating, I'm going to cut you off, all right?
Your Honor, the court is aware of Mr. Menendez's arguments.
Just heard it.
Just like to
And
say
read the motion.
Yes, Your Honor. As it
Okay.
relates to my client, Mr. Eppinger, we would contend that I believe it's counts. Let me find the exact one, Your Honor. I believe it's counts 38 and 39 of, no, I'm sorry, 28 and 29 of this matter, which charged my client with possession of a firearm by a first offender. The two counts are exactly written the exact same. They do not allege any different information whatsoever. And this counts 34 and 35, Your Honor. They allege that my client was in possession of a firearm on a particular date after having been convicted, placed on first offender for a particular crime. It is the same crime, the same date as listed in counts 34 and 35. There is no additional information required or added in this that would differentiate these two counts, Your Honor. So based on the similar arguments made before, we do believe that these counts are duplicative and should not be included in the indictment, Your Honor. Well, at least one of them should not. Thank you.
That it?
Yes, that's it, Your Honor.
Okay, all right. All right, Mr. Carlson. Can you speak to Mr. Menendez and by implication the rest of the defendants who have specifically decided to opt out are seeking to or have this court declare Georgia Rule of Evidence 418 unconstitutional, sir. So if you would speak to that, I would appreciate it.
May it please the court, Your Honor?
Go ahead.
All right, so this the prosecution right here. Let's see what they got to say.
And if I may, Judge, approach court reporter with my car.
You may.
Thank you. Your Honor, again, Mike Carlson, Executive District Attorney on behalf of the state, responding to the constitutional challenge. I believe it's actually to 1615-4, the charging provision of Georgia's Street Gang Terrorism and Prevention Act, as well as Official Code of Georgia 24-4-418, which is an evidence code provision that exclusively applies to cases charged under OCGA 1615-4, and that is by language of the statute. So, Your Honor, let's take a look first at what we have here. These are essentially facial challenges to both of these statutes before the court. There's no acknowledgement in the briefing that at least has been reviewed by this Assistant District Attorney of the controlling or persuasive authority involved. That begins with the fact of a presumption that a Georgia statute is constitutional, presumption that the challengers, the court knows, must rebut in cases like State versus Brannan, B-R-A-N-N-A-N, 267 Georgia 315, 267 Georgia 315, that's a 1996 case, sets forth. Also, in a facial challenge such as this, the opponents have to demonstrate that there is no set of facts under which the Gang Act or 1615-4 would be valid. Case for that out of the 11th Circuit is Benning versus Georgia, 391 Fed 3rd, 1299. 391 Fed 3rd, 1299. That's an 11th Circuit case from 2004. So accordingly, these challenges should be denied and the motion should be denied. Now let's take a look first at the challenge, which, and again, my apologies for not being here for all of the argument, but based on what I did here and based on the briefing, is a First Amendment challenge. Well, that was dispensed with, Your Honor, by our Supreme Court in a 2009 decision, Rodriguez versus State. 284 Georgia 803, 284 Georgia 803. Now, Rodriguez was strictly a case under OCGA 1615-4A, that's Alpha Judge, the primary charging provision of the Street Gang Act. But notably in Rodriguez, the court explained, and Justice, the late Justice's opinion affirming Judge Hancock of DeKalb County's decision, pointed out that the gang statute prosecutes conduct, not association and not expression. And I'll read a quote from the case. Criminal gang activity, quote, is not protected activity even when committed by a group exercising their constitutional right of free association, because, of course, there is no constitutional right to commit criminal gang activity. And when that criminal gang activity is committed by an individual who is a member or an associate of a criminal street gang and participates in the gang through the commission of that criminal gang activity, then the additional offense of a violation of 1615-4A can be brought. Now, there is a complaint here about 1615-4B. That is the commission of those offenses in order to increase or maintain status in the gang. Again, that is criminalizing behavior, not expression. So, as to the double jeopardy claim that we saw there, at the outset, let's direct the court and the record and opposing counsel to OCGA 16-15-4M as in Mary. That is a statutory non-merger provision that is housed within the Street Gang Act itself. And our Supreme Court and our Court of Appeals have specifically dealt with the issue of whether or not someone being charged with multiple subsections of the Street Gang Act and being sentenced and convicted, or convicted and sentenced for those subsections as well as the predicate offense, violates the Constitution. No merger, no violation in that case, Judge. And I want to take us first to the Court of Appeals case on that, Judge, which is Nolly versus the state, wherein the specific quote is that in Nolly, let me actually, before I get to the quote, the defendant was charged with more subsections than any of the defendants here were. And that was actually, there was an A, B, D, and E violation in addition to the underlying predicate. And the courts there said in Nolly from the Court of Appeals, and I'll have that citation to you in a second, Your Honor, from my co-counsel, there was no violation of merger or double jeopardy rules. Lupo versus State from the Supreme Court, 300 Georgia 233. That's a 2016 case. The gang activity counts did not merge, as that crime and malice murder each require a proof element that the other does not. And of course, that's consistent with federal and other state and Georgia RICO authority as well, Your Honor, which I'm happy to provide. Then there was Anthony versus State. Again, this is at 303 Georgia 399. We previously had rejected the idea that all gang offenses must be gathered into a single gang activity charge. So the subsections of the Street Gang Terrorism and Prevention Act all have different elements. Those elements are different than the predicate offenses, so they all can be charged, convicted, and sentenced separately. And in fact, there is a statutory non-merger provision within the act itself. So, Your Honor, the constitutional claims fail in terms of 1615-4. So now let's look at a later enacted statute, 24-4-418. Now, this is a provision that is unique to Georgia and only applies to cases that are charged under Georgia's Street Gang Terrorism and Prevention Act. And it's patterned after, Judge, the same evidence code provisions that apply in sexual offenses and lawsuits arising from acts of sexual misconduct. Georgia has those at 24-4-413, 14, and 15. They're in the federal rules of evidence under the same numbers, and I believe, Your Honor, they're also in the military rules of evidence under the same numbers. So the question is, does the admission of character evidence somehow in and of itself violate the Constitution? There's been no case law provided to that effect by the opposite side, and while the U.S. Supreme Court, I believe, has yet to definitively answer that question, there is certainly no controlling case law to say that these statutes, which are used and approved around the country, somehow violate the Constitution. So we ask a question, is there a due process problem here? Well, Rule 403 applies, Your Honor, and although it is a presumptive admissibility statute that does indeed allow other acts that qualify as criminal gang activity to be admitted for any purpose, including criminal propensity, those parallel the rules that apply in sex offenses, in federal courts and in Georgia courts, and quite frankly, in other states, California, for example.
Wait, what? Like, I thought this was like, what are we talking about? Like, sex offenses? Like, what is he talking about? Like, how is you correlating like gang violence and like, what is he talking about? If y'all understand how that correlates together, put that in the comments, because I'm real confused about that. And I'm like intrigued at the same time.
Your Honor, there are similar rules that apply in elder abuse cases, special needs abuse cases, domestic violence cases, as well as in non-sexual child abuse cases. Those have been upheld, and you'll see in our brief we've provided you with jurisdiction after jurisdiction after jurisdiction where rules that parallel this one, in fact, have been upheld constitutionally by federal and state courts around the country. An additional case on that, Your Honor, State versus Gee, G-E-E, that is at 388 Wisconsin 2nd, 68, 388 Wisconsin 2nd, 68, a 2019 case, and where they say, they quote the United States Supreme Court of Dowling versus U.S. 493 U.S. 342, 493 U.S. 342 at 1990, whether the introduction of this kind of evidence is so extremely unfair that its admission violates fundamental concepts of justice. Well, Your Honor, this type of evidence, even without the gang statute involved, even without 418, is generally admissible. The rules of intrinsic evidence are relaxed, generally speaking, when it comes to racketeering cases federally, and of course, in sexual offenses, even without a 413 or a 414, those were more easily admitted under our former evidence code. And just to go to a military case on that, Judge, U.S. versus McDonald, 53.
I will skip her.
With motions that will require witnesses, I should say.
Yes, Your Honor. So first, as to the duplicative counts, if I understood Mr. Farley's written motion correctly, it was a little different than what we heard today, but I'm happy to respond to all of it. So first of all, in his written motion, it seemed as though he was complaining that counts the indictment, later in the indictment, 50 and 51, mirrored some of the acts under count 1. So to respond to that first, Your Honor, first of all, as to count 1 acts 173 and 176, those are acts under the RICO count. They are not separate counts. So what's really going to drive us both through this conversation and through the addressing of what Mr. Farley talked about today, where he alleged that murder and criminal gang activity are duplicative of one another, there's some language that guides us through that. And what I cited to in my brief is the language out of Williams versus State, which is a 2020 Georgia Supreme Court case. It's in my brief, but if the court wants to cite, it's 307 Georgia Supreme Court 778. And in that case, the court said, the United States Supreme Court observed that a draftsman of an indictment may charge crime in a variety of forms and may cast the indictment in several counts, whether the body of facts upon which the indictment is based give rise only to one criminal offense or to more than one. Further, by an indictment of multiple counts, the prosecutor gives the necessary notice and does not do the less so because at the conclusion of the state's case, the defendant may insist that all counts are merely variants of a single offense. Here, the state was properly permitted to charge Farley's act of committing a gang murder, a gang-motivated murder, in numerous...
I ain't gonna lie, she way better than the other dude that was just talking. She sound more prepared. Dude, he was prepared, but she sound like she more about her business.
ways. The state was permitted to charge Farley with participating in the RICO conspiracy from the YSL criminal gang, and the state was entitled to allege acts that were in furtherance of that criminal conspiracy, as alleged in count 1. In count 49, 50, and 51, the state was entitled to separately charge Farley for the act of murdering Mr. Drinks and for participation in criminal street gang activity.
Which counts are those again? You said count 1?
My understanding is that Mr. Farley was challenging count 1, acts 173 and 176.
Okay.
And then also counts 49, 50, and 51. 173 and 176, count 1 acts 173 and 176 are Farley and his co-defendants' acts of murdering Mr. Drinks and participating in criminal street gang activity through that murder. And those acts are alleged as acts in furtherance of the YSL RICO conspiracy. And then additionally, Farley is separately charged in counts 49, 50, and 51 with the murder and participation in criminal street gang activity with the actual, those are the charges. So the charges that he's facing relevant to this count are that RICO charge, the murder charge, and the 2 gang charges. And the gang charges are alleged under separate code sections, separate divisions of the gang statute. So basically, these counts are not all the same, so this court should deny Farley's demur. And when I looked at this, what I believe is that this is a situation that should be analyzed similar to when a defendant complains of a double jeopardy violation. And I believe that this court should adopt that framework to analyze this challenge. The double jeopardy framework is that a single offense may be an offense against 2 statutes, and if each statute requires proof of an additional fact, which the other does not, an acquittal or conviction under either statute does not exempt the defendant from prosecution and punishment under the other. So I think to look here whether these counts are duplicative, it is whether it's similar to if we're looking at a double jeopardy or merger analysis. And here, these counts, none of these counts are the same. Count 1, count 49, count 50 or 51. Each of these counts requires the state to prove different elements. Simply because the state added language to certain counts stating that the victim about his gang status or gang affiliation, that does not mean that the counts are duplicative. It simply is different ways of alleging the act of committing a gang-motivated murder. These counts have different charging elements, and what's important is you look at the elements of each count. So Farley is charged in count 1 with RICO. Murder is not an essential, killing someone is not necessary to prove a RICO conspiracy violation. Same thing with participation in criminal street gang activity. Committing murder, killing someone, is not necessary to prove that someone violated the Criminal Street Gang Act. They could also be convicted of that and of murder, but it's not a situation where that's going to be a duplicative count. Those are different acts. And acts is probably the wrong word due to the RICO. Those are different actions taken by the defendant. They're differently charged, and that's completely appropriate pursuant to the Georgia Supreme Court, which quoted the United States Supreme Court. The United States Supreme Court case is United States versus Universal CIT Credit Corp. 344 United States 218, 1952. So here, Your Honor, the counts are not duplicative. They each require different elements. The state must prove different elements to show each conviction. Your Honor, these counts are in no way duplicative. Mr. Farley's demur should be denied.
Okay. Turn to the issue of the constitutionality of the gang statute, Georgia gang statute.
Yes, Your Honor. So turning to that directly, I think it's pretty clear that this has already been challenged by in the Georgia Supreme Court within the last 15 years. That was in Rodriguez versus State. And in that case, the Supreme Court of Georgia unanimously held that the primary charging provision of Georgia's anti-gang laws, OCGA 1615-4, is constitutional. Farley has not shown why this court should not follow the ruling of Rodriguez or even attempted to distinguish Rodriguez. So therefore, Your Honor, we believe that it's already been ruled upon. This is a challenge that has already been made. This statute is constitutional. And, Your Honor, going into the challenges to each of these, to the extent that Farley makes a First Amendment challenge, Rodriguez versus State held that criminal gang activity is not protected activity even when committed by a group exercising their constitutional right to free association. So that's already been held. Again, I think Mr. Carlson went into this as well, but to the extent he didn't, or the court has further questions, additionally, Anthony versus State loop specifically, and that's 303 Georgia Supreme Court 399. That's a 2018 case. The Georgia Supreme Court specifically rejected the idea that all gang offenses must be gathered into a single gang activity charge. In Lupo versus State 300 Georgia Supreme Court 233, that's a 2016 case, they found that an individual can be charged with separate violations for each of the gang statutes. So that's not a reason to find it unconstitutional. And generally, Your Honor, it's just been clear that this has already been challenged and been rejected, and Farley has not shown why this court should not follow pre-established case law. And Your Honor, I do want to provide the court additionally with the Nolly site that Mr. Carlson referenced. That's 335 Georgia Court of Appeals 539 2016, and that actually goes in support of both his case and his argument and my argument.
Okay.